Alrighty, so this is Chapter 8. We're going to look at traditional prosecution, arrest, bail, plea negotiations, settlement, and trial. So, without further ado, we'll continue onwards. So, traditional prosecution. Many criminal cases are simply dismissed for lack of evidence. And this is one of the things where you always look at winnability. For a lot of prosecutors, you're looking at the difficulties, you're looking at what can be implemented, and you're also looking at the element of, is this case going to initially win? For the vast majority of people charged with crimes and who are not fortunate enough to have the charges dropped, again, plea bargains, not trials, again, resolve the case. So again, for one of the things you're always looking at is seeing whether the charges can be dropped. And if that's the case, then a lot of times they'll go the way of plea bargains, just because trials cost a lot of money and a lot of time as well. Gathering evidence, gathering witnesses, making sure that you have enough factual information to initially present your side of the case. As noted, it was we have an adversarial justice system. Therefore, that's one of the things you're always looking at is, am I able to simply just resolve the case quickly? And plea bargaining, again, is a process in which a defendant agrees to plead guilty in exchange for some concession from the prosecutor. In other words, some level of reduction to the type of the charge, the number of charges, or in the recommended sentencing. Again, you're looking at the element of, even time spent. Is that one of the things that you're looking at? Are you able to initially combine sentencing and just to lower the time spent? So again, also by pleading guilty, defendants give up their rights to a trial. Within that, you're simply saying, yeah, I'm gonna plead guilty to it. And again, that's one of the things you're looking at is they want to make sure that you're of a sound mind when you initially plead guilty. Most civil cases are resolved without a trial in a process called settlement negotiation. So that's where you're pretty much negotiating. So you have a little tiny picture on the side. I find the picture kind of disturbing. It's a little creepy. But again, that's just me. So again, let's negotiate. I propose A, and the individual says I propose Z. Well, then I propose B. I propose Z. In that case, I propose C. I propose Z. Okay, it's Z then. That was a challenging but fruitful negotiation. So again, one of the things you're kind of going back and forth, and you initially kind of hope for the best, plan for the worst. So if the police believe that a suspect, so again, these are steps between arrest and trial. So again, if the police believe that a suspect committed a crime, they will most likely probably arrest the suspect. Charging implies a formal decision to continue with the prosecution, and that decision is made by the prosecuting attorney rather than the police. So again, prosecutors, a lot of times they're initially the ones who will go forward with the case. So again, in my time working with prosecutors, again, that's always been the initial outlook working on the reservation. So the Fourth Amendment. So the initial appearance. The Fourth Amendment to the United States Constitution requires that any person arrested be brought before a judge within 48 hours of arrest. So that's where you would have the 48-hour window. So even if they are incarcerated, they initially have 48 hours to initially appear before the judge. Again, this also applies on the Navajo Nation. The judge reviews the evidence summarized by the prosecutor and determines whether there is reason to believe that the suspect committed the crimes charged. So again, you have the Fourth Amendment off to the right. So the judge will inform defendants of the charges against them, inform them of their constitutional right, review the issue of bail, and appoint attorneys for those that cannot afford to hire their own. Again, this is more for, say, for example, the state of Arizona, but for the Navajo Nation, you would have to find your own attorney. There is no public defender. So again, we utilize a lot of restorative justice. And so again, it's one of those elements. So again, you have to at times find an attorney. And again, that's where a lot of family members are having to initially go out of their way to hire an attorney and everything else. And there are attorneys that work near the border towns. I've met a couple in my time working on the Navajo Nation. And within that, some of them are pretty good. But within that, it's one of those things where, if possible, and I think that's one of the things, if possible, sometimes some individuals are not able to hire an attorney. So again, that's where you kind of you either can go through DNA, legal services, or you can go through the attorney and see if they're willing to do pro bono work. In other words, working for free. And so within that, that's one of the things is you want to make sure that you're able to have a fair, if it does go to trial, or even if you're going forward, you still want to have somebody talking on your behalf, because again, a lot of cases, just due to the wordage, I think that's or the verbiage, a lot of times you have individuals who don't understand the legal system, and they may agree to something not knowing that it has a more impactful element to it, therefore jeopardizing their initial case. So the prosecution must offer some evidence on every element of the crime charged, and the judge must decide whether the evidence is sufficient to pursue the case further. Again, no jury is present, and defendants rarely testify or offer any evidence of their own. So again, the judge will sometimes send the case to a grand jury or reduce the charges, either because he or she believes the evidence does not support the level of crime charged by the prosecutor, or because of an initial plea bargain. So Poplar State coach Jerry Sandusky was able to avoid prosecution in Happy Valley until a 2-year grand jury investigation. Again, he was charged with 52 counts of deviant sexual intercourse, endangering the welfare of a child, indecent assault, the rape of several young boys between 1994 and 2009. So currently he is serving a 30 to 60 year sentence. So there you have Jerry Sandusky off to the right. So the grand jury, again, consists of citizens drawn from the community. The grand jury meets in private with the prosecutor to investigate criminal activity and return indictments. In other words, complaints prepared by the prosecutor describing the crime charged. So the grand jury, again, may call witnesses if it is dissatisfied with the witnesses presented by the prosecutor. In some states, the defendant has a right to testify. So again, in about a third of the states, a criminal defendant cannot be prosecuted unless a grand jury has found grounds to do so. The remaining states permit the prosecutor to proceed either by grand jury indictment or by a preliminary hearing. If the grand jury decides there is sufficient evidence to justify the defendant being tried, it issues an indictment. So at their arraignment, the judge makes sure that the defendant has an attorney. The defendant is asked to plead guilty or not guilty. It is customary for defendants to plead not guilty at this time in order to provide opportunities both for discovery, in other words, the defendant attorney can review some of the evidence against the defendant, and for plea bargaining if possible. As noted, like I said, plea bargaining is one of the, I want to say it's the catch-all in terms of trying to ensure that an initial bargain can be met so as not to go to trial. As noted, trials take time, takes money, resources, etc., and it's time-consuming. A lot of times when we watch movies, we kind of look at it and everything is over in 2 to 3 hours and we go about our everyday lives, but for trials, a lot of times they go a lot longer. And so that's one of the things you're kind of taking into consideration. So again, you have discovery and pretrial motions. So again, the defendant and their attorneys want to be aware of the evidence the prosecution will use to initially prove its case. Civil cases, each side is entitled to discovery. Each side can question the other side's witnesses and review documents that the other side might use at trial. So there you have the pretrial motions. You have motion for discovery, motion to suppress evidence, motion to dismiss, motion for severance of defendants, and motion for mistrial, motion for new trial, and motion for change of venue. I believe we went over motion for change of venue and majority of these over in the past slides. So criminal cases, what the prosecution must reveal to the defense varies. Most states require only that the prosecutors share evidence that is exculpatory. In other words, this would be information that tends to show the defendant is not guilty or suggest that prosecution witnesses are not credible. In many states, the defense is required to notify the prosecution if it intends to rely on insanity or an alibi defense. So here you have a little excerpt on the side, and evidence that is favorable to the accused is exculpatory evidence. The gun bore a single fingerprint that did not belong to the accused. So again, that's one of the things you're looking at is exculpatory evidence as you're going forward. So Timothy Masters was just 15 years old when the body of a 37-year-old female was found near his trailer park in Fort Collins. Within that, Timothy allowed police to search his room and school locker, and they found 2,200 pages of violently misogynistic writings and drawings, and a collection of knives. No physical evidence was ever linked to Masters at the crime scene. Excuse me. Oh, boy. At trial, an expert witness, forensic psychologist, concluded, without having ever spoken with Masters, that some of the drawings represented Masters reliving the crime. Although some of the jurors had doubts about his guilt, they convicted him based on his drawings and writings. So here is Masters and the victim. Here are the scary doodles. These are a lot of the artwork that was kind of seen within the initial 22, within the images, actually. So here's Timothy Masters. Masters was released from prison after 9 years when DNA evidence exonerated him. Again, a review of the case showed that investigators had a second suspect and suppressed evidence to ensure the conviction. The prosecutor had concluded with the investigators for the conviction. So there you have Timothy Masters, in other words, Tim Masters. Says he wants Lieutenant Jim Broderick held accountable for a murder investigation that began when Masters was 15. So again, you can also click on this image right here, the lower left image, for the allegations against Broderick that are now being presented. So the lower left, just click on that one, and it'll take you to the initial site. So here you have, during the discovery phase, both sides can file pretrial motions seeking favorable rulings on the admissibility of evidence. And we'll kind of go through these. You have motion for separate trials, motion to sever counts, motion for change of venue, motion to suppress a confession, and motions in limine. In other words, a request for a pretrial ruling. So, motion for separate trials. When there are two defendants, often one of the defendant will seek a separate trial for fear that being tried together will result in a prejudicial decision. So, if you look on the bottom, I don't know if you guys remember that, and this was with, you have Timothy McVeigh and Terry Nichols. So again, they were tried separately. So Garrett, you also have the current, which is Derek Chauvin. The individual where the individual had the knee on the neck of, I believe it was George Floyd. And so again, that's where you have separate trials. So each one will initially have a separate trial, so as to initially try each independently. But again, you also have the news article there, so you can click on that as well. So if a defendant, so this is a motion to sever counts. So if a defendant is charged with multiple counts, again, they may choose to separate the charges and be tried in separate trials for each charge. Again, this may reduce the prejudice created by some of the more onerous charges. They will also get separate juries. And then motion for change of venue. So again, this kind of goes into the area of, say, for example, if word gets out that initially the community opinion kind of weighs in, so the defendant may request a change of venue, moving their proceedings to another location on the grounds that the community opinion, usually the product of prejudicial pretrial publicity, makes it impossible to seat a fair-minded jury. Because again, you are being tried by your fellow peers, and you want to make sure that their initial judgment is not swayed. Within that, psychologists are sometimes involved in analyzing the extent and impact of the publicity on prospective jurors. So again, that's one of the things you're looking at. You're looking at, what is the impact? What is the extent to which the prospective jurors may have knowledge of the case, and will it impact their ability to make an initial clear outlook? And then motion to suppress. The Fifth and Sixth Amendment protects Americans from self-incrimination and the use of a statement taken without benefit of counsel. Again, that's one of the things is self-incrimination. You don't want to initially incriminate yourself, saying the wrong thing. And that's where at times, the attorney that you hire will be able to speak for you and also allow you not to say the wrong things. Often a motion will be filed to suppress statements made by the defendant, including a confession that a judge will have to rule on before a trial can proceed. So motions in limine, again at the start, are merely pretrial motions that set limits on what evidence will be allowed during proceedings. While these motions are usually filed by the defendant to suppress select pieces of information, they are also used by prosecutors to determine the range of acceptable evidence, so initially creating a boundary, what to include and what to exclude overall. So the decision to set bail, judges must decide whether to keep criminal defendants in custody between arrest and trial. And with that, they can also decide to release them with a promise that they will reappear, and to make sure that they're not going to run off to Mexico or Tahiti or some other country or continent. They want to make sure that the individual does come back to initially for the initial elements that will be presented. Again, judges can deny bail. Again, if the defendant is a flight risk. So the individual may have frequent flyer miles, and therefore, once released, they may take off to wherever. Again, require that money be deposited with the court. Again, can use a bail bondsman. Then also require that a third person be responsible for the defendant's future appearances. In other words, forfeit money if the defendant doesn't appear. So this individual will be the one that kind of will ensure that the defendant will be available and will be present. And if they're not, what will happen is that person will have to face that initial element of the forfeiture of the money. So again, if they don't appear, they will have to forfeit money. So the decision to set bail, in addition to ensuring the defendant's return to court, bail has a secondary purpose. Excuse me. Sorry. Protecting public safety. Again, you have a little kind of excerpt on the side. But one of the biggest things you're looking at is ensuring that the people of a community are safe. So the decision to set bail. Again, they are influenced by both legal factors and extra legal factors. So legal factors would be seriousness of the offense, and extra legal would be defendant's race, gender, etc. So again, legal factors, research has shown that bail is likely to be denied or set very high when the offense was serious and when the defendant has prior convictions. So again, that's what they're taking into account. They're taking into account. Oh boy, excuse me. They're taking into account the prior convictions. Then you have the extra legal factors. Race, gender has been shown to have significant impacts on judges' pretrial release decisions. For example, black defendants were less likely than other defendants to be released, and female defendants were assigned lower bail amounts than males. So here you have mental heuristics. So again, you have the initial shortcuts. And this is where psychology kind of blends in. And again, each one, I guess one of the things you're kind of looking at is the blending of how does psychology kind of blend into the legal system. I mean, you can see that from chapter 1 all the way to where we're at right now. One of the things you're looking at is, for a lot of judges, what do they use? They use a lot of mental matching heuristics when determining whether a bail should be allowed. They search through a subset of variable and available cases and then make a decision on the basis of only a small number of factors. You're looking at offense severity and prior record, and this is where they often ignore other seemingly relevant information, things that can kind of be better applied. And this is that where you begin to look at therapeutic jurisprudence, and you can see the impact. You can kind of see how judges initially play out their decisional factors. So again, a decision to set bail. Moving forward. So does pretrial release affect trial outcome? And the answer is yes. Defendants who are detained in jail are more likely to plead guilty or be convicted and receive longer sentences than those who can afford bail, even when the seriousness of their offenses and the evidence against them are the same. So can high-risk defendants be identified? So again, around 1970, a push began for legislation that would increase the use of preventive detention, the detention of accused persons who pose a risk of flight or dangerousness. Again, this assumes that valid assessment of risk and accurate predictions of future dangerous conduct can be made. And one of the uniques is Reyes points out that there is no recognized diagnosis of dangerous. So again, you kind of have an initial juxtaposition in terms of one being applied, but also trying to utilize preventative measures. Does it always work out? And the answer is no. So future dangerousness, this is where the concern kind of comes up. So you have the APA, both APAs, American Psychiatric and also the American Psychological, initially having strong objections because one of the things is the legal system has regularly indicated that the psychiatric experts can initially predict future dangerousness. But again, not only are these, if you go farther down, it says not only are these predictions laced with uncertainty, but for the purpose of a trial, they are more prejudicial than probative. Again, it's one of those things where when you're looking at dangerousness, trying to figure out dangerousness, again, as noted prior, there is no actual diagnosis for dangerousness. So within that, it kind of puts things in a catch-22. You're damned if you don't, you're damned if you do. So again, it's one of those areas where what can be done to initially, again, that's where you kind of just have to advocate that element of informing the court that initially this is, there is some uncertainty. And I think that's one of the things that a lot of individuals kind of bypass, because initially, like I said, for trial cases, they're extensive. So again, they're very adversarial. Therefore, one side wants to win over the other. So again, they're going to utilize as much as they can to initially win the case. So the concept of dangerousness is oftentimes analyzed. Certain facets of an individual's personality may provide indicators as to that individual's predisposition to engage in dangerous behaviors. Again, for instance, APD, in other words, aggressive personality disturbances, may influence an individual's increased tendency to engage in violence or even criminal behavior. Again, it can be broken down to a series of affective, interpersonal, and behavioral traits or lifestyle characteristics. But again, that's one of the things you're looking at. It's a concept. So you're trying to make sure that you're able to look at it analytically and try to break down the initial elements that kind of make up an individual. So here are various forms of aggression. You have medically related aggression, you have impulsive aggression, you have instrumental aggression, you have affective aggression, you have predatory aggression. So these are the different areas. Is aggression resulting from some type of identified medical disorder? That would be for medically related aggression. For impulsive, it involves Spontaneity, in other words, hair-triggered responsive aggression that cannot be connected to a neurological abnormality. Again, this aggression is reactive. There's a level of stimuli provoking fear, anger, or rage. Then you have instrumental aggression, driven by the expectation that a reward will follow the violent behavior. And then you have affective aggression, intense autonomic arousal, as well as a subjective experience of emotion, usually anger or fear. Typically, aggression is expressed as an immediate response to provocation. As such, its purpose is usually to reduce or eliminate the threat and return to biological homeostasis. Then you have predatory. Initially, these are carefully planned, calculated, tailored, and targeted towards particularly chosen individuals. So again, there's a level of selection. So the predictions of future dangerousness are typically derived from a series of psychiatric risk methods that can be broken down into three categories. You have unstructured clinical judgment, you have actuarial assessments, and structured clinical judgments. So again, these are the various assessment tools utilized. So unstructured, not all are alike. So again, each one will kind of go through those. So the unstructured, these initially lack consistency. Clinical assessments tend to overlap regarding diagnostic criterions. And again, it's going all based on clinical judgment. But again, these are unstructured. So initially there's no, all the evaluations are not completely agreed upon by the other evaluators. So it kind of jumps back and forth. Then you have actuarial assessments. So these would be the initial application of a standardized risk scale, constructed specifically to predict violent recidivism. In other words, violent outbursts that will happen again. Uncertainties regarding the accuracy of VRAG's prediction of violence in populations where there are a few prior offenders. With respect to first-time offenders, VRAG is an especially weak tool. So if this is a first-time offense, it's going to be really hard to detect recidivism. It's going to be one of those things where you're trying to predict for troubled behavior, but you have nothing to go off of. And that's where the VRAG kind of has its limitations. And then you have the structured clinical judgment. Again, this is a decision-making process assisted by guidelines developed to reflect the current state of discipline within professional practice. It allows for sufficient flexibility to account for the diversities of human personalities and the context in which assessments are conducted. Moreover, it provides for transparency and accountability. And the reason why it allows for that is because there is a structure to it. There is something to fall back on. There is a guideline. There are tools that you can initially follow to initially get a better outlook. Versus the unstructured, it's very, I don't want to say it's rudimentary, but you're initially just going off of judgment itself. You're going off of your own personal clinical judgment from what you've seen in the field and applying that. And so again, that's where you have that element of it being very limited. So plea bargaining in criminal cases. Most criminal cases end prior to a trial with a plea bargain. Again, the defendant pleads guilty, and within that there is an exchange for some concession from the prosecutor. In charge bargaining, the prosecutor drops some charges in return for a guilty plea. Prosecutors often overcharge to be in a good position for this. So this is where the prosecutor may charge for this, that, and the other to simply say, we're covering all our bases. And so that we're able to, say, for the individual may say, hey, I'm going to plead guilty to this. Can you reduce it? So again, it doesn't necessarily detract from the initial implementation of what is going to be applied to the case itself. So plea bargaining may also take the form of sentence bargaining, in which prosecutors recommend reduced sentences in return for guilty pleas. In general, judges will follow the sentence recommended by a prosecutor. Again, that's one of the things you're kind of looking at. So plea bargaining in criminal cases. Why do defendants plead guilty? That's one of the questions we always ask. We always ask that question of, why did that person do it? Oh my gosh, if that was me, if I was in that situation, if I was, placed in that situation, I would never admit to guilt. I would be, I would fight it tooth and nail. But the reality is, sometimes individuals, there's a high likelihood of conviction. And number two, because the victim, because if convicted, they would face lengthy sentences. So again, a lot of times they'll plead guilty. But again, you want to try to make sure that the individual is of a sound mind when they plead guilty. And that's where that time window kind of comes in. So why do prosecutors plea bargain? Again, to dispose of cases in which evidence against the defendant is weak or the defense attorney is a formidable foe. Again, like I said, winnability. So if you're looking at it thinking, okay, if I'm going to press onwards and is this going to reflect badly on me? Do I, is this, that, and the other? Do I have enough evidence? And can I just simply plea out and everything else? And then also to ensure a win. Number three, to obtain a testimony of one defendant against a more culpable defendant. And number four, to expedite the flow of cases. As noted, even on nomination, even just working within the prosecutor's office at times, caseloads pretty much build up pretty quickly. And at times it just keeps building and building and building. And sometimes you just have to kind of, to expedite. You have to actually lower the caseload and everything else. So again, that's where you have a lot of plea bargaining kind of happening. So this is Shane Guthrie, 24, was arrested in Gainesville, Florida, in 2010, charged with aggravated battery and false imprisonment of his pregnant girlfriend. Again, Guthrie was initially offered a plea deal of 2 years in prison and probation. Guthrie refused. The prosecutor then offered him 5 years, and he declined. So again, the prosecutor didn't get Guthrie to plead guilty, so a year later he filed first-degree felony kidnapping charges, life imprisonment if convicted. So again, he went from 2 years in prison to 50 years in prison because he wouldn't take the plea deal. Because again, the element of how far is too far, and that's one of the things you kind of take into consideration. So psychological influences on plea bargaining processes. So framing effects. Again, the way decision alternatives are framed, in other words, the gains or the losses, can have an impact on a person's choice. When you look at individuals, are they more willing to take chances when the decision alternatives are presented in terms of gains than in terms of losses? So again, you have the framing effect occur when two logically equivalent but not transparently equivalent statements of a problem lead decision makers to choose different options. For example, people support an economic program when it is said to result in 90% employment, but then oppose the same program when it is said to result in 10% unemployment. So you notice just even the wordage, similar in a framing effect, occurs when choosing between risky prospects. Individuals tend to prefer risk-averse alternatives when the outcomes are framed in terms of gains, saving lives, making money, but shift to preferring risk-seeking alternatives when the equivalent outcomes are framed in terms of losses, dying and losing money. So again, if you look at those elements, it kind of, you look at how people's perception is swayed based upon how the information is framed and how it is presented, therefore resulting in the element of what is considered the framing effects. So if you can make things be presented in a more beneficial way, then an individual may be more swayed to initially take that alternative. So overconfidence, why it can be a bad thing, and I think I want to say this is the slide that I went through with lawyers, but one of the things is the overconfidence bias. People tend to be too optimistic about their chances of securing favorable outcomes. And it's one of those things where you want to look at life in terms of a more positive outlook, but within this, you tend to be more optimistic, too optimistic about your chances of securing favorable outcomes. Parties in court systematically overestimate their chances of success. Again, you also want a lawyer who hopefully is wanting to succeed. But again, it's one of those things where sometimes the overestimation can be damaging. It can actually be impactful. Just like Guthrie, there was an element of overconfidence, and it resulted in him having a longer and more lengthier sentencing. So, evaluation of plea bargaining. So, advocates cite the following justifications for plea bargaining. 1, guilty pleas relieve the backlog of cases. Number 2, facilitate the prosecution of other offenders. And 3, the absence of a trial reduces the involvement of various criminal justice personnel. So again, that's one of the things you're kind of looking at. You want to make sure that you're looking at the evaluation of simply just plea bargaining itself. A lot of times it relieves that backlog because, again, you have cases that are built up upon one another. And sometimes for some individuals, they've just been sitting there for so long. And a plea bargain kind of comes along and it's like, all right, I'll take this alternative. And also the facilitate the prosecution of other offenders, more serious offenses. At times where individuals who are incarcerated, a lot of times they'll initially just take a plea bargain just to lower their incarceration so that they can free up the jail situation to allow individuals to allow individuals who are more serious offenders to now then be housed in the jail itself. And number 3, the absence of a trial reduces the involvement of various criminal justice personnel. And that's one of the things you're looking at, the absence of a trial. So if there's not a trial, it'll reduce the involvement. Other personnel kind of coming in, other judicial presence there. So again, that's one of the things you're kind of looking at. You want to make sure that you're not necessarily involving everybody, because again, it also takes time away from their initial duties. So again, it's one of those things where a lot of individuals are always looking at it from the angle of, well, that's why they get paid for that. Yes and no, because one, if you involve everybody else, it kind of detracts from their duties across the board. And so again, that's just kind of things that kind of impact the initial outlook of just that initial flow. And so again, that's one of the things you're kind of looking at, is ensuring there's a level of flow going on, if that makes sense. So critics cite the following justifications for plea bargainings. So again, improper sentences, sometimes too harsh but more often too lenient, are likely. The process encourages defendants to surrender their constitutional rights, and prosecutors exert too much power. And number 4, innocent defendants might feel coerced to plead guilty. And a lot of times that's where it comes down to. Some individuals, some critics will cite the following justifications for plea bargaining. Some individuals may feel like, hey, I'm an innocent defendant, and I feel like, hey, I might as well just plead guilty because it seems like the guilty plea is a lot more beneficial in my favor, even though it's a lighter sentence. It just seems more favorable, and I get in and I'm out and everything else. So settlement in civil cases. The vast majority of civil disputes are resolved without a trial. And these are what is considered settlement negotiations, typically in private negotiations between attorneys representing the disputing parties. A lot of the times this will happen in within the civil courts. So again, the legal merits of the case matter most. Outcomes are also influenced by the negotiator's reservation price. In other words, the defendant's reservation price is the maximum amount of money that he or she would be willing to pay to reach an agreement. So again, the plaintiff reservation price is the minimum amount of money that he or she would accept to claim the settlement, or to settle the claim. So in considering the merits of a case, plaintiffs, defendants, and attorneys are influenced by heuristics, in other words, the psychological biases. In other words, a self-serving bias occurs when people interpret information or make decisions in ways that are consistent within their own interests, rather than in an objective fashion. For example, parties often have difficulty seeing the merits of the other side. So again, you have a small little excerpt which indicates self-serving bias. Yay, A plus. I'm so smart. So again, they take credit for the positive events. And then F grade, the teacher does not like me. In other words, blame external factors for negative consequences or negative events. Again, the same thing applies in our everyday lives. That's the reason why a lot of individuals, even for friendships and everything else, they'll kind of go through those different elements. And the same thing happens within the court system. Judge may say, hey, this is what's happening. And the person might say, hey, you know what? The judge doesn't like me. That's the reason why they. And again, they're just taking into account the external factors. But if they say, for example, if things go in their favor, they look at it from the angle of, well, it's because I have a good attorney, or I have a good this, or I have a good that, and they take credit for the positive events. So again, those are kind of the things that you can come across within the cases as well. So the anchoring and adjustment bias occurs when negotiators are strongly influenced, in other words, anchored by an initial starting value, and do not sufficiently adjust their judgments away from the starting point. So the higher the first offer, the higher the ultimate settlement. And so again, that's where they anchor themselves and simply are unable to be budged. So the purpose of a trial, what is the purpose? So Miller and Boaster, 1977, have identified 3 images of the trial. So the trial as a search for the truth. I think this is where a lot of people kind of get into that element of, you can't handle the truth. Again, it's the assumption that the truth can be ascertained and that it will emerge from the confrontation of conflicting facts. And that's where we always look at the element of Lady Justice, who is blind. And a lot of times as they're going and muddling through the whole process, they believe that, hey, truth will be applied and we'll be able to find the truth. And it also assumes that judges or jurors can put aside their prejudices. But we've seen that in the cases where individuals, when they come to cases, they've already have certain prejudices. They already have certain elements. They can't just simply shut off their own personal feelings or their own personal subjectivities. And they decide the case with a dispassionate analysis. And we would like that. We would like individuals to decide the case with a level of dispassionate analysis, a level of unbiased outlooks. But again, one of the things is sometimes a lot of it comes down to biased interpretation. And it can be difficult to meet this ideal. Number 2, the trial as a test of credibility. So again, this acknowledges that facts and evidence are incomplete and biased. Judge or jury must weigh and evaluate the truthfulness of the opposing sources. And this is where the unfortunate truth comes forward, where both judges and jurors can make unwarranted inferences. In other words, they can simply read the case wrong. They can read the evidence wrong. They can read the information wrong. And then the trial is a conflict resolving ritual. Again, this provides a mechanism to resolve controversies to create the sense that justice is being done. So again, these are all the different elements of what is the purpose of a trial. So here you have the preliminary actions of discovery. So again, the pretrial process by which each side tries to gain vital information about the case that will be presented by the other side. This is where you're gathering evidence, police records, etc. And this is one of the things where you don't want to initially be ambushed. In other words, a trial by ambush. You want to make sure that you know what you're preparing for. You want to make sure that you have enough information. Within the next slide, you'll kind of have a breakdown of what is considered jury duty. And within that, you'll have an actual video. So if you can, just click on that and you'll have the information. So here you have drawing panel prospective jurors called venire from a large list. In other words, these are individuals that are usually pulled from voter registration lists and lists of licensed drivers. This is where you get called for jury duty. Once a venire for a trial has been selected, a process known as voir dire is employed to question and select the eventual jurors. So the trial. So the opening statements. So a lot of times the lawyer for each side are permitted to make opening statements. Again, this is not part of the evidence, just overviews of the evidence to be presented. So the prosecution or plaintiff usually goes first within a defense opening, follows immediately after, or the defense can choose to wait until it is their turn to initially present evidence. And after opening statements, the prosecution or plaintiff calls its witnesses. Each witness testifies under oath with the threat of a charge of perjury if the witness fails to be truthful. Each witness undergoes direct examination, cross-examination, redirect, and recross. So again, here you have Rule 603, oath or affirmation to testify truthfully. Again, before testifying, a witness must give an oath or affirmation to testify truthfully. It must be in a form designed to impress that duty on the witness's conscience. Again, you're making that oath. Again, the rule is designed to afford the flexibility required in dealing with religious adults, atheists, conscientious objectors, mental defectives, and children. Affirmation is simply a solemn undertaking to tell the truth. No special verbal formula is required, as is true regarding affirmation is recognized by federal law. Therefore, oath includes affirmation. Again, this is one of those things where you have individuals who, are making an oath on a Bible, stuff like that. But again, it's one of those things where you're just simply making an oath overall. So the trial. After the prosecution or plaintiff attorneys have presented all their witnesses, it is the defense turn. Each witness undergoes direct examination, cross-examination, redirect, and recross. So here you have a breakdown of how a jury trial kind of looks. And if you notice, a lot of it's pretty straightforward. So after both sides have presented their witnesses, one or both may decide to ask the judge for permission to present rebuttal evidence, which attempts to counteract or disprove evidence given by an earlier witness. So once all evidence has been presented, each side is permitted to make a closing argument, in other words, a summation. Typically, the prosecution or plaintiff gets the first summation, followed by the defense, after which the prosecution or plaintiff responds. So again, if you notice, a lot of it is nail-biting and just exciting work. If you've ever had a chance to sit in trials, a lot of times it's very lengthy. In other words. So again, the final steps in the jury trial is for the judge to give instruction to the jury. Some states' instructions precede the closing arguments. Again, the judge informs the jury of the relevant law. Again, the judge also instructs jurors about the standard they should use to weigh the evidence. With criminal charges, the jurors must be convinced beyond a reasonable doubt that the defendant is guilty before they vote to convict. In a civil trial, the ponderance of the evidence is necessary for a finding in favor of one side. So again, these are the initial weight that is initially applied. When the jury has reached its verdict, its foreperson informs the bailiff, who informs the judge, who reconvenes the attorneys and defendants and plaintiffs in a civil trial for announcement of the verdict. So advantages to the prosecution. The prosecution is first to address the judge or jury. It has full resources of the government. The prosecution presents its evidence before the defense. And at the end of the trial, the prosecution gets to go first and also get the chance to offer a final rebuttal to the defense's closing argument. So herein is, you're probably wondering what exculpatory and inculpatory kind of means, and we'll kind of go into that right here. So the advantages to the defense, again, it does not bear the burden of proof. The prosecution must turn over exculpatory evidence through the element of discovery. Defendants may have more opportunities in the prosecution to remove potential jurors without giving a reason, and defendants do not have to take the stand as witnesses on their own behalf. Defendants who are found not guilty can never be tried again for that specific crime. In other words, double jeopardy. If you ever have a chance, watch that movie with Ashley Judd. And within that, you have exculpatory So again, what is exculpatory? Information that increases a defendant's probability of innocence or absolutely relieves them of liability. And simply that is just legalese for indicating that this increases the defendant's probability of innocence. In other words, this information allows the defendant to initially walk free, in essence. Often used to describe evidence in a criminal trial that justifies, excuses, or creates reasonable doubt about a defendant's alleged action or intentions. And then conversely, inculpatory evidence demonstrates culpability or legal responsibility for a given act. So again, that's one of the things you're looking at is liability. And so within that, that's kind of what exculpatory and inculpatory kind of breaks it down for. Hopefully that kind of explains those elements. So sentencing. The defendant in a criminal trial is judged guilty. Punishment must be decided. In most jurisdictions, the trial judge decides punishment. So in 2004, the U.S. Supreme Court ruled that judges may not increase defendant sentences on the basis of what they perceived as aggravating factors. In other words, circumstances that seem to make the crime worse. In Blakely v. Washington, 2004, the court reserved those determinations for juries. So this is where you implement it through the jury of your peers. And if you click on that, if you click on it, it'll take you to the link of the Blakely v. Washington case. So in a handful of states, sentencing is determined by a jury. In cases involving the death penalty, jurors rather than judges decide the sentences. And this is Ring v. Arizona, 2002. There you can also find a link there. So any defendant has the opportunity to appeal a verdict to a higher level of courts. So this would be the Court of Appeals. So this would be the appellate process. Appeals are also possible in virtually every civil suit. And this is where you keep going up and higher and higher. Now you go through the appeals court. So for an appeal, the appellate judges read one, the record, in other words, the transcripts of the trial proceedings, and two, the pleadings, the motions and accompanying documents filed by the attorney, and the briefs, written arguments from both sides about the issues on appeal, and then decide whether to overturn the original trial decision or to let it stand. So again, that's what it goes through, that process. And again, one of the things is you want to try to go through those processes. If, say, for example, you feel like, hey, there was still a wrongdoing of justice and everything else in my case. So appellate judges rarely reverse a verdict on the basis of the facts of the case or the apparent legitimacy of that verdict. When they do reverse, it is usually because they believe that the trial judge made a procedural error, such as allowing controversial evidence to be presented. So here's the appellate process. Again, can correct mistakes that impair the fairness of trials. It also helps promote a level of consistency in trial procedure. So here you have the Supreme Court, Appellate Court, and District Court. So again, with the Appellate Court, there are 13 courts, 179 judges. So again, there's a small little emoji at the bottom, little cartoon. One, I don't accept the verdict. The judge didn't properly apply the law. Then the other individual says, then go to appellate court. They'll see if it was incorrect. And that's one of the things you're kind of doing is you're doing a check and balances. But again, like I said, it does take time and everything else. So if a verdict in a criminal trial is overturned or reversed, the appeals court will either order a retrial or order the charges thrown out. In a civil case, an appellate court can let the decision stand. Either that or they can reverse it, rule in favor of the side that lost, or make some other changes in the decision and remand the case to a lower court for reconsideration. In other words, return the case to a lower court for reconsideration. Oh, I can't even say the word. So video courtrooms of the future. So again, you have video conferencing. This was kind of during my day. It was slowly being implemented and everything else. Again, this kind of goes into, say for example, domestic violence cases and stuff like that. If you don't want to see if you don't want to face the perpetrator, etc., or even for child abuse cases. But again, you're also looking at those elements of safety In this day and age now, and I don't know if you guys saw that, there was an individual who was in a trial, and the lawyer was suddenly a cat. And the next slide, I'll have that little kind of excerpt. So the video conferencing that permits live two-way video and audio communication, electronic and digital evidence, computer animation and simulations. Again, this helps. This helps in presenting the case and the evidence. And also virtual environments, technologies that allow observers to experience a recreation of an event as if they were actually present when it occurred. Again, this helps to kind of gain perspective versus before where just telling a narrative it was good, but this one kind of gives you kind of a more in-depth outlook. This cannot be stressed enough. Please make sure to check your equipment. I think that's one of the things is always become comfortable with what you're utilizing. You don't want to be like the lawyer who now turned into a cat. So again, that's one of the things is you have the video here, or not the video here, but you have a little picture here, and you can search for the video online. So that's kind of one of the things you want to always make sure of. And just the fact of the courtroom, I think that's one of the things is the if you've ever worked with lawyers and everything else, it's a very different feel. There's almost a higher level of professionalism that kind of goes into it, and you initially try to preserve that. And so when this is happening, I can almost feel that initial pain that the lawyer is going through. So again, it's one of those things where you have these uniquenesses that can come up now, just with the utilization of what's going on right now. Just due to the pandemic and everything else, you're starting to see a greater reliance on a lot of these tools, and within that, you're going to see probably a greater reliance on it as we continue onwards. And this may just be a new avenue that we initially can begin to implement. And this one. So here you have, if you have a chance, watch this one. This small little YouTube. So there's a link there. Click on that, and it'll kind of link you to watch this little area and how the justice system has kind of changed. And so again, this is kind of for your entertainment. So again, that's there. So on to the next chapter. So again, if you have any questions, send me a link or an email or a text or whatever. And we'll be moving on to the next portion. So again, the next portion will be kind of delving into the next chapter. So be awesome, be amazing. Until next time.